Do you understand?
Yes, sir.
Oh, you tell me the truth?
Yes, sir.
Really? Like you did before under oath?
Yes, sir.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. Today's courtroom moment involves a defendant facing serious allegations that once carried the weight of a first-degree felony. But things take a dramatic turn when a plea agreement, a sworn statement, and a shocking contradiction collide in front of the judge. The real question is simple, but powerful. Did the defendant lie under oath? Or is he trying to take back a plea that could send him to prison? As the judge starts digging for the truth, what follows is a tense exchange that could completely reshape the outcome of this case.
We call 23-41449, the state of Texas versus Lance Dixon. That is you. Present with Mr. Burbank, your attorney, and the state's attorney. Earlier, you pleaded guilty to the offense of assault of a child, which was a lesser included offense of trafficking, continuous trafficking of persons, which is a very serious first degree felony. This is a second degree felony, and the agreement was reached here by the parties that whatever sentence shall not exceed a cap of 10 years in prison. So there are some variations that go with this. Different options. Pre-sentence report has been prepared if the parties had an opportunity to review it. Any changes or corrections to it, state?
I've reviewed. I have no changes, Your Honor.
I've reviewed it, Judge. I have a motion, I guess.
Go ahead.
Ask that we withdraw the plea.
What a waste, you know, this is a waste. But I know, here's his version.
Let's pause right here because this is where things get legally interesting. The court is dealing with a $4,318.92 balance, but the defendants are disputing $1,027 based on money orders they claim were properly purchased and cleared. Here's the issue. Money orders typically don't bounce like personal checks unless there's fraud, processing error, or misrouting between financial institutions. The judge makes a credibility call here. He openly states he doesn't believe the property representative would risk her courtroom credibility by falsely claiming NSF funds. That's huge. In small claims and landlord-tenant matters, credibility is everything. If those money orders truly cleared Western Union, the defendants need hard documentation, not screenshots, not assumptions, bank confirmation. Question for you. If you had receipts showing payment cleared, would you trust the system to fix it, or would you be nervous walking back into court?
What happened on the day you committed the offense? Your response was nothing. Nothing happened. But you pleaded guilty under oath in front of this court. Were you lying during your plea of guilty to me, or did you lie to the pre-sentence officer when you said nothing happened? Which one? Which one, sir? You can't say both of them. Which one? I'm sorry?
I don't even know what I was signing.
You didn't know what?
We didn't know what you were signing, Judge.
Do you speak English? Do you read English? We've never had that problem in 20 years. It's simple. We go over it. He goes over it, then I go over it. Congratulations, you're the first literate person who can't understand any of this. You pleaded guilty under oath. We went over it slowly and methodically. That sounds like perjury. Yeah, lying under oath. Have you spoken to Any of the people involved in this? The other people, the victims?
The victim approved the agreement that was made on this date. Your Honor, on November 17th, when we entered this plea, that was the day of the trial docket. This was going to be the number one case. And
Yeah.
at the time during the docket, my victim was here. There was communications between the defense and we reached this resolution. And so to say I'm disappointed in
Okay.
the
What do you want?
statements
What
is
statement?
beyond-
What do you say? He's asking to withdraw the plea. I believe I'm obliged to do that. And here's what we're going to do
Yes,
is,
sir.
it was set for trial
Yes, sir.
and I want it in 2 weeks. Can you be ready in 2 weeks? 3 weeks?
I want to try this case, Judge. I want to hold him responsible.
I know we were all
before-
ready that day. What will it take to get ready?
That's what I need to find out. If I first given some latitude,
Available moment.
if I can be given some latitude
And
to
let
get
me
that
find
answer.
out.
Yes,
I
sir.
want to know if you had any contact with any of the people involved. Let me know. Then we'll
Yes, sir.
have a bond hearing immediately. And we'll deal with that. But this is
Judge,
very bizarre. This never happens.
This moment right here shifts from civil frustration to serious criminal stakes. The judge breaks down alcohol dissipation rates, 0.0125 per hour, and calculates backward to show that if Mr. Bodie's still had a 0.088 reading, he was heavily intoxicated the night before. That's not just a lecture, that's a warning shot. Here's why this matters. He's facing a 10-year felony for assault with intent to do great bodily harm, plus 2 additional 4-year felonies. And on top of that, there's a no alcohol bond condition. Violating bond conditions while awaiting felony proceedings is extremely dangerous legally. The judge even says if he had jurisdiction, he'd lock him up immediately. That tells you how serious this is. Showing up intoxicated to court when your freedom is on the line? That's playing with fire. Be honest, if you were facing a decade behind bars, would you risk even one drink?
And we're going to figure out if there's some sinister motive behind all of this. Because nobody has ever said, I can't understand English. I can't understand the methodical method that we go through in doing a plea. And I didn't understand that. That never happens. That's why you've gotten my attention.
Judge, this man has no GPS monitor on him. I believe that Your Honor would have done that had that been brought to your attention. I was going to do that if the case was not reached. Since we reached a resolution, I did not request any additional changes. I would ask that you look at that in light of the fact that the original offense is trafficking and we need to know where this man's whereabouts are.
Can I respond?
Yes, you know.
This is a 2019 case. He's appeared every day time in court. It's not done. There's been no violations on his bond.
That we know of.
Well, Mr. Burbank, here's the problem. You're asking me to trust him after what he just said, after what has happened in this plea hearing. No, I'm sorry. That's bizarre. And he made statements and assertions under oath, which now he is refuting, and I can't trust anything now from him. So yeah, the request for a GPS device is ordered. We're going to know where you are at all times, and just let me find out you had any contact with any of the victims or the people involved as witnesses in this case, except for defense witnesses. And we need a hearing on that immediately. But the first thing is, we were all ready for trial. It was the day of trial. We're going to pick that up.
Yes, sir.
The earliest moment we can try this case. I want to review it in 2 weeks where we are and be ready for trial.
Yes, sir.
That-
Will you place a time constraint as to when he's going to get this monitor on?
Immediately,
Thank you,
end of
Judge.
day.
Gotta go down and get it tomorrow. So,
You understand?
Thank you, y'all.
Do you understand?
Yes, sir.
Oh, you tell me the truth?
Yeah, sir.
Really? Like you did before under oath?
Yes, sir.
Now, this is a powerful judicial moment. The foreclosure buyer tried to accelerate the redemption period, arguing code violations, specifically missing exterior stairs, justified early possession. But the judge pushes back hard. Why? Because redemption rights are statutory protections. After a foreclosure sale, October 16th in this case, the homeowner typically gets a fixed redemption window, here likely 6 months until April 16th. That means unless there's serious destruction or waste to the property, courts are reluctant to cut that time short. The judge essentially says, this statute wasn't meant for minor code leverage. And then he does something interesting. He advises the homeowner to get the money together and preserve equity. That's not favoritism. That's protecting due process. Losing a property over less than $10,000 when equity exists would be devastating. Do you think the judge was being fair here, or too protective?